It is plaintiff's motion, plaintiff father's motion for parenting time and other matters. Matters adjourned from June 21st. This hearing is being conducted via Zoom. Present is Attorney Christine Hills representing the plaintiff father, Seth Evans, and Mr. Evans is present. In addition, the defendant, Jessica Brubaker, is present. Good morning, everyone.
Morning, Your Honor.
Your Honor.
Have the parties completed the high conflict solutions workshop?
They did, Your Honor, and I have certificates of completion for both, which we'll be emailing to Ms. LaPrade a little bit later this morning.
Thank you. Hopefully the parties derived some benefit from that class and program. Mr. Evans, was the class worth your while? I was like input. I don't want to order people to go through these classes without getting some input.
No, Your Honor. I thought the high conflict parenting. I thought it was very good. I learned a lot from it.
Right.
It was worth my while.
All right, thank you. That's what that was the inquiry of the court. What about you, Ms. Brubaker? Was it worthwhile?
Yes.
Okay. There's just enough challenges in life. We want your 4-year-old Faye to do well in life, and they will do well if you're both on the same page. That's all we're trying to accomplish here. In any event, good morning, Ms. LaPrade.
Good morning, Your Honor.
The party set before Ms. LaPrade this morning. Have to refresh. I'm not receiving a recommendation, Ms. LaPrade, but I'll close out and reopen.
Your Honor, that's my fault. I redid one part of it and I did not finish completing it. So it should be there now.
So the party set before Ms. LaPrade. Ms. LaPrade's provided court find recommendation. Father's parenting time shall be as follows: every other weekend, Friday after school or 1 p.m. if there's no school until Sunday at 3 p.m. Father shall continue to have phone calls with my child on Tuesdays and Fridays at 5 p.m. In addition, father shall have a Christmas 1 for 2023, which is December 22nd after school until December 24th at 5 p.m. Mother will ensure that father is listed on all registration paperwork and authorized for pickups and emergencies. Mother acknowledges that she is in contempt of court. Review of parenting time sentencing and contempt shall be adjourned to January 9th, 2024 at 9 a.m. Court will reserve the issue of attorney fees requested by the plaintiff, and the parties will research app close to determine whether or not that's appropriate means of communication. That is recommendation. Ms. Sills, is this recommendation good with your client?
Your Honor, with the exception that we would ask for a little bit more time on Sundays for Mr. Evans' weekends, we are in agreement with the recommendation. Ms. Brubaker indicated that the child's bedtime is 6:30, which seems a little bit early, but all children are different. He would ask that he have the child until 4 o'clock on Sundays. His original request had been 5, but if we could get until 4, that gives him another hour. He's got every other weekend parenting time. There is a distance. She's in the Cleveland area. He obviously lives in the area here in Michigan, and that would give him a bit more quality time on the weekend with their daughter.
It's a reasonable request. Ms. Brubaker, any objection to dad's having parenting time until 4 p.m. on Sundays rather than 3 o'clock?
Yes, we're currently at 1 o'clock, which works the best during the school year. Summer is a whole different story, but we just went back to school last week, and adjusting when she comes home to go back to school on Monday is hard for her. Sunday, she comes home exhausted, and it's just hard for her to wind down and get back to bed and get back into her routine for school on Monday mornings. So
she's in preschool. She's correct.
Yeah.
She's not in kindergarten yet.
No, she's in preschool.
Okay. Where do the parties meet, Ms. Hills? I'm sorry, Ms. Brubaker. I thought you were done.
Still exhausted, so it's just rough for her on Monday morning.
They meet about halfway, Your Honor. My clients indicated that it's somewhere around 45 minutes or so. from their meeting point to where Ms. Brubaker lives. So that should still,
It's about an hour and 15 minutes.
so that still should get the child home in a reasonable amount of time to have a bite of dinner or snack and get a bath or whatever the nighttime routine is.
But she still kind of needs like a wind down period, and you know, it just goes straight to bed. So Seth keeps her up a lot later than she is at home. Yeah. So it's an adjustment when kids come home from a different home. When they switch homes, that's an adjustment.
Well, the court would agree 5 or 6 o'clock on Sunday is too late if during the school year, but the court does not find that 4 o'clock is unreasonable, so the court will modify the recommendation to allow father to have parenting time until Sundays at 4 o'clock. So the parties will meet at 4 o'clock. And that should give Faye an opportunity to unwind. She's got an hour and 15-minute drive back home and dinner and so forth and bathing. So that 4-year-olds are pretty resilient. She should be able to settle down for Monday. Who will initiate the phone calls on Tuesdays and Fridays? Will Dad do that?
Yes, Your Honor.
All right, Ms. Brubaker, any other concerns about this recommendation?
About the Tuesday, Friday phone call?
About any of the recommendation. The court's going to modify the recommendation so that Dad should have every other from Friday after school or 1 p.m. for no school until Sunday at 4 p.m. Phone calls Tuesday and Friday at 5 p.m. Dad will initiate those phone calls. And also the Christmas, Dad will have Christmas 1, which is from December 22nd after school until December 24th at 5. And then we'll come back to this court to review these matters, including sentencing on contempt, request for attorney fees on January 9th at 9 a.m. Do you have any other concerns, objections to the remainder of the recommendation?
Just that Seth has been a couple minutes late. I mean, to meet, to pick up Faye on Friday, like he meets my mom to pick up Faye during drop off and pick up. And so I worry that he is going to be late to pick her up from school. And I mean, he can't be late to pick her up from school. So I think I'm at the school anyways. I am on the PTA. I am a room mom. I don't understand why he needs to pick her up from school when I'm there anyways. So I don't know why he needs to drive 2 hours to pick her up from school. And possibly late. I don't know how many times he can be late or we realize that that's an issue. That's my only concern.
Okay. Obviously, you're active in Faye's school, which is wonderful. Parents should, but
Right.
Dad should also be active in the school. Dad should be able to observe what goes on in the school. Perhaps he can be there early, so he can perhaps observe some of the activities in the preschool. So obviously, if it becomes an issue when we come back for review in January, the court will put a halt to that. So Mr. Evans, is very critical that you be on time, if not early, for all those pickups from school on Fridays.
Understood.
Even if you came a couple hours early, you can reach out to teachers. Maybe perhaps you can even sit and observe. I don't know, it could be a distraction to the child. I don't know, but you need to be active in your child's preschool education. So let's give it a try, Ms. Brubaker. And if there's concerns, he's late, then we'll address it and come back in January. If not before, you can always petition the court before. If there's a serious issue and can't wait till January, you can always petition the court for relief in the interim.
Okay.
But let's give it a try. Anything else, Ms. Brubaker?
No.
All right, the court will adopt the recommendation. The only modification will be as the added parenting time will be extended to 4 o'clock on Sundays rather than on alternate weekends rather than 3. It's even on Sundays when you do the exchanges, both of you need to be on time if there's some plan on traffic congestion. You don't want the child waiting in the car for any period of time. So as a courtesy to each other, be on time. If there's an accident or whatever, phone the other party, let them know it as soon as possible. There's going to be a delay, but try to make every effort to be on time, if not early. All right, if there's anything further, Ms. Hills?
Nothing from us, Your Honor. Thank you.
All right, the court will adopt the recommendation as slightly modified, and we'll share one in January.
Thank you.
Copies
Thank you,
will be mailed
Chair.
to you, Mr. Baker. You're welcome.
Thank you.
Thank you, Mr. Pratt. These matters
Thank
are
you, Your
before
Honor.
the
That
court
updated
on the
recommendations in your queue.
Father Adams' motion to modify support and receive direct payment credits, as well as Adams' motion to modify parenting time and to compel discovery. This hearing is being conducted via Zoom. President Attorney James Petrangelo representing the father, Adam Sowards. Mr. Sowards is present. In addition, Attorney Maria Zagorski is present representing the mother, Ashley Sowards, and both Ms. Sowards are present. The parties have conferred at length this morning with Mr. Walker. For the court, Mr. Walker has provided the court following recommendation, which first of all provides that the DC case 2021-6921-DC shall be consolidated into this DM case. Everyone agrees with that. Further, it's recommended that the Adam, again, he's placed with one case, defendant the other, but the Adam, who's a defendant in the DM case, shall receive a child support credit amount of $4,300. The front of the court shall update its records to reflect that credit. All future child support payments shall be paid through MISDU or directly to the front of the court. The issue of modifying child support is reserved pending mediation. Court's aware parties are meeting with Attorney Godfrey on November 20th at 8:30. And if I recall, there's probably most likely a review scheduled immediately following that mediation. Further, the following opportunity to have parenting time via Zoom and email at mutually agreeable times and dates pending mediation. Mother shall leave the room during those Zoom parenting time sessions and not interfere with the children's Zoom phone calls with father. That's a recommendation. Mr. Petrangelo, is this recommendation agreeable to your client this morning?
Your Honor, a portion of it is, I believe this recommendation resolves the child support and credits issue. We have agreed to the $4,300 credit. We have agreed all future payments to be through MISDU or the front of the court. The child support be reserved pending mediation, and we're agreeable to the consolidation. The parenting time and discovery matters we'd like to address.
Okay. Before we address that, Mrs. Gorski, I'll let you address the recommendation before we hear further from Mr. Petrangelo.
Yes, thank you, Judge. We have no objection to the recommendation. I would just note that our agreement is not an acknowledgement that mom is interfering with parenting time in any way. We have no objection because she's not, but we have no objection.
Thank you. Mr. Petrangelo, your clients obviously want some personal contact with the children, and the children are residing in Mexico right now.
Yes, Your Honor. Your Honor, when the parties entered into a judgment back in May of 2022, they were granted joint legal custody, and that generally grants my client a right to have a say in major decisions, including medical, health, education, religion, and so forth. And those issues we think are all relevant, and our discovery questions regarding those things are relevant. Furthermore, the parties agreed that my client would have this Zoom and email contact, but they added, which is not typical, specifically that this would be done with the objective to improve the relationship between plaintiff and minor children to warrant in-person contact in the future. Now, this has gone on for 15 months. My client claims obstruction with these Zoom conferences, and I know that's denied. Ms. Zagorski has raised a number of things in her response that I would point out to the court all precede this judgment. In other words, yes, the court made indications on the record. Yes, the parties made claims in the past, but everybody put that aside and agreed to this specific plan, that this was the way to go forward. And this was agreed by the parties, agreed by counsel, agreed by the court, based upon that. And I think it's time after 15 months, it's clear voluntarily we're not going to get an agreement to in-person time. While we think it'd be ideally, if money wasn't a factor, these kids should be brought up here on a regular basis for parenting time with dad. But at a minimum, we think dad should be given a chance to see if there's a way to break the ice with some controlled contact for him to be able to go to Mexico. Let's pick a spot, put reasonable procedures in place, let him go periodically and see them. It is natural with this length of time they've been apart for there to be apprehension on the part of the kids. And I think giving dad a chance before there's any other interviews or other things going on to see if he and his kids can't soften the situation. And I think it's reasonable. As to the compelling discovery, again, I think these are all areas of relevance that must be addressed in any judgment. Things like custody have to be addressed, parenting time. And again, my client does have joint legal custody, and it's acknowledged the kids have had a number of serious physical problems health-wise. So I think this is not a case where my client has been breaking the rules to go down there and try to get around the current situation. He's dutifully tried to work through the court. And I think if the court wants to indicate if he's given this location information and other details he's requested, he's not to otherwise go down there or interfere except as permitted by the court, there's no reason to believe Mr. Sowards won't honor that. So those are our requests, that we start some time. We'd ask in the next 6 weeks that he be allowed to go have a visit. We'd like to do this before the mediation. I think that'll help shed some light, at least preliminarily, on the situation.
When did Mr. Sowards last confer or have a Zoom conference with the children? And did that involve all the children or just some of the children?
I'd have to ask Mr. Sowards that, if I may, right now, Your Honor.
Approximately a month ago.
Why so long ago?
The Zoom meetings are being interfered with. All the children aren't present, and they're being queued off camera to shut the meetings down in an attempt to alienate the kids from me.
Well, why didn't you try to do it every week, Mr. Sowards?
I have been, Your Honor.
Okay. So when you reach out to schedule a Zoom, the children don't respond. Who do you communicate with, or do you communicate with your wife?
They respond, and I have approximately 45 to 50 Zoom meetings recorded that, if needed in the future, I can provide evidence of the obstruction and parental alienation. When the Zoom meetings are going really well, they're queued off camera, and they're told to ask inflammatory questions, or one of them will even shut the meetings down. Ashley acknowledged that this morning during our friend of the court hearing, that she's queued Lawson and Gabriella to shut the meetings down. This is on record as well. I can provide those recordings to the court.
Right, answers the court question, and I understand certainly parents should have right to have some physical contact with their child when it's been more than 15 months. Ms. Sikorsky, is your client opposed to Mr. Sowards at his expense flying to Mexico to have spend a weekend with the kids?
Yeah, before we
Realize
get to
we can't
that,
force the kids.
before we get to that, am I to understand, Mr. Sowards, that he was recording our mediated session with Mr. Walker this morning?
No, I recorded all of the Zoom hearings.
Oh, okay. So, Judge, in response to your questions, his last Zoom meeting was August 12th. So it was about a month ago. He requested a Zoom, and that happened. On September 5th, Gabriella asked what happened to the Zoom meeting and was ignored. He's had 31 total meetings since May of 2022. And of course, we categorically deny that we are interfering. Lawson, my client, acknowledged that Lawson did shut a meeting down because he's the oldest son, because Mr. Sowards was being inappropriate. Mr. Sowards often says inappropriate things and wants inappropriate information. But the reason that we're opposed to in-person parenting time at this time, Judge, is threefold. First of all, as I indicated, we have mediation next month. In fact, we're between mediations with Mr. Godfroy. The second reason is the money. Mr. Sowards is routinely in arrears. In fact, he's with Ms. Hicks this morning at 10 o'clock because he does not pay his child support. He's $13,000 in arrears on his property settlement payments, and you will be getting a petition in order to show cause on that. And Most importantly, there's been no change in his behavior. At best, a licensed professional should be in on these Zoom calls between the children and Mr. Sowards to facilitate this relationship. But when you have the party's oldest son, and I had him testify before, Judge, and I know nobody likes to do that. I can do that again. When you have the oldest child shutting down a Zoom session because Mr. Sowers isn't behaving himself, that's a problem. So, even Mr. Petrangelo acknowledges that it could introduce apprehension on the part of the children to see their father in person. Why would we do that until we have more information? Mr. Soward says things are going swimmingly. My client says they're not, but we have children that are shutting down the Zoom. So I would say that in-person parenting time, first of all, shouldn't be granted because Mr. Sowards can't afford it. He's not paying what he's already been ordered to pay. And second of all, we simply need more information about the relationship. There's no prima facie evidence that anything has changed whatsoever.
Thank you, Ms. Zagorski. Of course, parenting time, with all due respect, parenting time and the child support are two separate issues. We can agree upon that. But there is some merit in when the parties meet with Mr. Godfrey, if there was at least an attempt at physical contact, it would give everyone a basis to determine where we go from there. If in fact Lawson chooses not to participate and see his dad, then that's Lawson's choice. The court recalls very clearly his testimony. I think it's the first time since I've been a licensed attorney that I've experienced a child testifying. But Lawson's testimony is pretty clear. But the court would like to schedule perhaps a weekend where Mr. Lawson could go. Where Mr. Sowers could go out there and the children would be available. The children choose. All I'm asking is a mom encourage it. If the children choose not to, then so be it. But let's try to make at least one attempt between now and that November 20th mediation. That might give a basis for the parties to move forward. Maybe then we could agree we need a psychological evaluation of Mr. Sowers. I don't know, but what about just a weekend? A long weekend where Mr. Sowers can fly out there at his expense. Again, it's his choice whether or not he can afford it in light of the child support arrearages, but the court might give him that opportunity. If we can do that in an environment where the children are, we say, how old is the youngest child, Ms. Zagorski?
Oh gosh, Ashley, how old is Elijah these days? 6? He's 6, Judge.
Okay, well, they're all old enough. And obviously they have siblings that can look over after them if there's an issue or dad's being inappropriate. What's your client's proposal, Mr. Petrangelo? Long weekend?
That would be fine, Your Honor. We talked in terms of, for example, picking a resort where dad flies down. Mom could bring the kids there so that they could meet dad at the resort. Mom's got control of their passports, so it's not like dad can flee the country with them. There'd be, some agreement that, the sessions take place at the resort so they can be using the facilities and kind of just have a nice time at the pool kind of arrangement. And that seems like something where dad's not coming to her house or anything like that. There's certainly reason to think that they're not going to be in any danger or risk of any harm in that kind of environment.
I'm sorry, would Lawson have the authority to terminate the parenting time if Mr. Sowers is inappropriate or abusive?
I'm not sure if Lawson, with what's been described, would be maybe the right person, but.
Well, Lawson could certainly just leave, if he can go back to his room or Mr. Gorski, but I don't want him to terminate on behalf of the remaining children. If the remaining children, and obviously Lawson is very strong, and obviously he's the oldest and he has pretty strong ideas. I want him to be in charge, terminate parenting time with the other children. So the court suggests that we perhaps couples could talk and agree upon a resort that's close by mother's home where it's convenient. I don't know where mother lives. I don't know if we're talking about the Cancun area, that there needs to be, if we're talking about overnight, there'd be appropriate hotel rooms for the children in terms of separating the boys and the girls. And I guess the other question is, would mom be present?
How do we guarantee the children's safety if Lawson can only take action, can only remove himself?
Does he have a cell phone? Can he call mom and say, Mom, pick me up?
Well, what if Mr. Sowers is inappropriate with the younger children, though, is my concern. Yeah, sure, Lawson can walk away.
I mean,
well, if there's an issue, couldn't Lawson call mom and say, hey, dad's being I don't know, when you say inappropriate, I'm not sure what that means. Mr. Gorski, is he saying inappropriate things? Is he acting inappropriate?
Yes, all of that. Asking the children, for example, where they live, asking them what doctor they see, asking them where they go to church, all the things that can help him identify where my client is.
Well, Miss Howard should be disclosing if the children go to school, where the school is, if they go to church, where they go to church. Okay, maybe
But
not
she-
through releasing her physical address, but the parties do have joint legal custody, so she should be informing him of where the kids are educated and where they go to church, if any, and those kind of things.
Well, and she does. Judge, Mr. Sowers knows the children are homeschooled, and we attach medical records and their education records, as you know from my response. My concern goes to Mr. Sowers asking the children questions that would identify where they reside.
Well, and Miss Howard is concerned about her personal well-being and safety. Is that correct?
For safety and the safety of the children.
The court would hope that Mr. Sowers would not injure or physically harm his own children. But there obviously should be no questions asked about where they live. Obviously, they live in Mexico. Mr. Sowers doesn't need an address. So I don't know. I guess one thing the court can do is put it over for a couple of weeks. Council can discuss the parameters. The court's inclined to permit a long weekend for dad to have parenting time in Mexico, personal contact with the children. If council wants to, do you want to confer while everyone's here this morning? Try to work out some of the details.
If the court's inclined to grant that, certainly we can, if I can briefly talk to my client, I think most packages to go to a resort area are something like a minimum 4-day, 3-night kind of arrangement. And if court's thinking about something along that line, I'm sure we can pick a weekend.
Yes.
And,
That's what the court's contemplating, but it's got to be convenient, and we don't want to be in a 2-hour drive from mom. It's got to be in the same vicinity, and so the party says we need to be communication between council in terms of, okay, dad's thinking this resort, and is it convenient for mom? Those kind of details council have to work through. But yes, the court's inclined to provide some personal contact in Mexico, an appropriate resort for the children, appropriate overnight accommodations for the children, and yes, of course, taking just a long weekend, maybe 3 nights.
Then I would ask that you put this over for 2 weeks for a couple of reasons. I don't even know where my client lives, so I can't even begin to have that conversation today. I would like to get with her and figure out what would actually work for the children and herself. The other thing is we had a 10 o'clock with Ms. Hicks and I have a 10:45 with you, and I'm concerned about backing up your docket.
Okay, so we'll give you.
Your Honor, I mean, couldn't we just say mom will designate a resort in Mexico, a resort location, a city, whatever it is, within the next week? I don't know why we need 2 weeks. She knows what's nearby.
Okay, so you don't want to come back then? You'll just leave it to the parties to work out, Mr. Petrangelo, if the court orders the long weekend parenting time between now and November?
Your Honor, no, I'm not saying I don't. It just, we probably ought to before then have, I don't know why mom can't designate that within a week. And then when we come back in 2 weeks, we'll be able to have lined up more detail on exactly, when we're going and so forth.
Best I can do on my docket is September 26th. It's a Tuesday. It's 2 weeks from today, either at 1:45 or 3:45. It's the only times I have slots I have available, Mr. Petrangelo.
Okay, let's see.
3:45 is great.
Okay, Mr. Gorski suggests 3:45, so we put this in our docket to review dad's request for personal contact. The court's inclined to permit it if the parties can discuss, try to work out details, and to the extent they cannot work those out, the court will address those on September 26th at 3:45 p.m. Mr. Walker, if you're still there, can you add this to the recommendation? The court review. There's Mr. Walker. Can you just add one sentence at the bottom of this? The court will otherwise adopt all remaining recommendations. The court will simply put on our docket September 26th, 3:45 to review dad's request for in-person parenting time in Mexico.
Do that, Your Honor.
All right, thank you. Anything further this morning, Mr. Petrangelo or Mr. Gorski?
No, thank you, Judge.
Is the court ordering then that all information except mother's residence location be provided pursuant to our discovery?
That's a pretty broad question, all other. So I guess she knows it. He's aware of their schooling, correct?
Yes.
We're aware that she represents that's homeschooling.
I can't do any more than that if they're homeschooled. I can't provide the name of a school if they're homeschooled.
But doctors, employment, church, things like that.
Mr. Petrangelo, you can discuss that with Ms. Gorski in the next 2 weeks, and the court will address those if necessary when we come back in 2 weeks.
All right.
Yes, she should be able to advise whether or not the children go to church, and if so, what church. And the names of all medical providers, pediatricians. If the children have any specialty needs, medical needs, that those should be disclosed to the father. So we can address that when we come back on September 26th at 3:45.
Thank you, Your Honor.
You're welcome. All right, that'll conclude this matter. I know everyone's got a busy schedule this morning.
Patrice, can we go forward without Kayla?
I told her to wait for me. She was on her break at work. She may have gone back to work. As far as I'm concerned, yes, we can go forward. I have a rec ready to go.
Good morning, Ms. Patrick.
Good morning, Your
Welcome
Honor.
back.
Thank
Had a nice
you.
time.
We had a very nice time, but it was very hot. So,
Roll call the case of Stephen Johnson Jr. versus Kayla Bodine. This matter is before the court on defendant's parenting time show cause hearing, referred to this court's docket by the front of the court referee near pass. This hearing is being conducted via Zoom. Present is the plaintiff father, Stephen Johnson Jr. And Ms. Bodine apparently was present. Ms. Patrick, you discussed the matters with Ms. Bodine, and she apparently had to go back to work and could not remain until the court called the case.
I believe
Is that
that's what
correct?
happened, Your Honor. She did hear the recommendation. I asked her to wait, but then I was instructed that she had left the breakout room. She did mention she was on her break from work.
All right. Good morning, Mr. Johnson.
Good morning, Honor.
The recommendation of Ms. Patrick this morning, if adopted, will come to order of the court. It's recommended that it's noted that you are requesting adjournment to have an attorney present until the further court hearing. The parties, parents should meet at St. Mary's parking lot at 4 p.m. until 6 p.m. on Saturday and Sunday, September 23rd and September 24th. Father shall not exit his vehicle. Mother shall take the child to the playground. Your fiance shall not be present, and mother shall not have any third party present.
Yes, Honor.
Ms. Patrick, obviously, when the child is there, dad can exit the vehicle, just not during what's meant by that phrase.
That he'll not go to the playground. Mom was afraid that the child wouldn't act the same. So the phrase is just that it's understood dad's going to stay in the parking lot as
Okay.
mom goes to the playground with the child. That's all, Your Honor.
All right, the child is currently with dad, so dad will simply drop off the child, let the
Correct.
child exit the vehicle to meet mom at the playground and stay in his vehicle.
Right.
Thank you. Do you understand the recommendation, Mr. Johnson?
Yes, sir.
Any objection to court adopting this?
No, sir.
Finally, Ms. Patrick, we need a review date. Is that correct?
That's correct, Your Honor.
How much time do you need, Mr. Johnson, which to retain an attorney?
My attorney said he just had another case that got held up on.
Okay, we'll put it
He's
on
supposed
for
to
the
be here.
26th. We'll put it on for the 26th of September,
1:45.
1:45.
I can check with them.
No, he's got to be here. Or they got to get another attorney, September 26th. I'm not going to drag us out for a month.
Yeah.
So Collier, we're going to put this in the order. The court review will continue this matter to September 26th. It's 2 weeks from today's date, 1:45 in the afternoon. Write that down. Call the attorney. And if the attorney can't be there, maybe the attorney can make some other arrangements to move other matters so he can represent you at that time. If not, then you need to find another attorney.
Yes, sir.
So you got to appear on that date with or without an attorney. Then we're not going to adjourn it any further. You aware of this ahead of time? I mean, you had plenty of time to contact an attorney that was available. So, Ms. Patrick, we can simply add to this that the matters continue to September 26th, 1:45 p.m.
Yes, Your Honor.
via Zoom. Right. Any other questions, Mr. Johnson?
No, Honor.
Okay. So on the Saturday, not this coming Saturday, but the following Saturday and Sunday, 23rd, 24th, you shall deliver the child to St. Mary's parking lot at 4 o'clock. Stay in your car until 6 o'clock.
Yes, sir.
And your fiance shall not be present. Mother shall likewise just be by herself to welcome the child. And you need to let Anya know that she's going to be spending time with her mom. So you got to encourage that. Any child needs an active mother as well as father in their life. So let her know in advance, and hopefully she'll be excited to spend time with her mom in that playground. And hopefully the weather will cooperate.
Oh, she's been looking forward to see her. She, like I said, she missed last 4. They never contacted me what's going on or nothing. So I got left.
Okay.
I looked it up.
Okay. All right. We'll see you back then in 2 weeks, September 26th at 1:45. All right. That'll conclude this hearing. Mr. Johnson, you can zoom out. The copies will be mailed to you. For the record, this matter is before the court for the purpose of reviewing defendant father's parenting time. This hearing is being conducted via Zoom. President Attorney Leslie Carr representing the plaintiff, Mother Brooklyn Moss. Ms. Moss is present. Is Christopher Tyson present on audio? It appears he is not. This matter was scheduled at 10 a.m. It's now 10:25 a.m. Mr. Tyson has not appeared. He's not contacted the court. The court would note that the parties were before the court back on July 25, 2023. Mr. Tyson was present, at which time the court entered an order advising him at that time in the record that the matter would be continued to today's date, September 12th at 10 a.m. So Mr. Tyson obviously was aware of the date and time. Ms. Carr, when's the last contact Ms. Moss had with Mr. Tyson? You know?
At the last hearing is the last time she has heard from Mr. Tyson. She has not heard from him since that hearing.
Okay. Of course, the last order entered, the court suspended the plaintiff father's parenting time until he's available and willing to exercise parenting time. Obviously, his failure to appear today suggests he's not willing or able to exercise parenting time. So the court this time will reserve his parenting time until he petitions the court in order to that effect. Anything further, Ms. Carr?
No, thank you.
All right. That'll conclude this matter.
Thank you, Your Honor.
Thank you, Mr. Brad.
Thank you.
Welcome.